you're not walking out of this courtroom today. Either you're going to be going to prison or either you're going to be going to inpatient treatment. You're going to get drug tested today. What are the results going to be?
They will come back positive.
Positive for what?
Methamphetamine. I just do it when I'm under stress. So I know I have a problem and I don't do it like around my children. I don't do it, every day. It's just, when I'm under stress and I was, really scared. So, and really under stress. So I don't do it when I go to work. I don't do it, every day, like I said.
I'm going to find her guilty, sentence her to.
All right, everyone. Today's case brings us into a tense courtroom moment with an unexpected angle. A mother stands before the judge, caught in a serious legal battle that could change a life. The atmosphere is heavy, and every word spoken in the courtroom carries weight as the decision day finally arrives. She is facing a possible 6-year federal sentence after authorities connected her to a large quantity of illegal substances. The evidence is strong, and the consequences are real. Yet, what truly grabs attention is her own statement to the judge, where she admits involvement but tries to downplay it by saying it only happened occasionally. That single claim sparks a lot of debate. On the surface, she appears calm and sincere, almost convincing in the way she speaks. However, sincerity alone does not erase evidence, and the court must focus on facts rather than feelings. The judge is left to weigh accountability against emotion. Now, this is where opinions divide. Some may feel sympathy, especially considering her role as a parent, while others believe the law must be applied without exception. So the real question is, does her explanation hold any real power in a courtroom like this? If you enjoy following real court cases and thoughtful legal commentary, make sure to support the channel by liking and subscribing. Share your thoughts below, because these discussions matter, and your perspective adds to the conversation. Now, let's get into the details and see how this courtroom drama unfolds.
All right, we're here for sentencing today. According to the plea bargain agreement, she pled no contest to count 2 of the indictment. She applied for deferred adjudication. The state is proceeding only on count 2 according to the plea bargain agreement. Punishment is to be assessed at 6 years in the prison, and the state is silent on the defendant's application. The court requested that the defendant's criminal history be provided to the court. There were no objections to the court receiving that from the state. Is that correct?
Correct.
And any objections to the court reviewing that?
No, Judge, of course not.
All right. The state is silent. Is there anything you wish to say on behalf of your client?
Judge, of course, Ms. Torres is hoping you'll grant her application for deferred. She's self-employed, cleaning houses. She has several customers that rely on her. She has a few kids. She's just asking for the court to maybe direct her to some outpatient treatment because she believes she needs some help with this problem. And other than that, again, she's just hoping you'll grant her application.
All right. You want to raise your right hand for me, please? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right. You can lower your hand. State your name for the record.
Missy Ann Torres.
All right. So you're going to get drug tested today. What are the results going to be?
They will come back positive.
Positive for what?
Methamphetamine.
All right. So how often are you using meth?
I only do it when I'm under stress, and I did it because I could get denied for adjudication, so
I'm sorry, what?
I could get denied the application, so I just do it when I'm under stress. So I know I have a problem, and I don't do it like around my children. I don't do it, every day. It's just when I'm under stress and I was really scared, so and really under stress. So I don't do it when I go to work. I don't do it every day.
I have to be honest here. This explanation raises a lot of serious doubts. When do you ever hear someone claim they only use a highly dangerous illegal substance once in a while? That idea alone sounds hard to accept, especially given how widely known these substances are for being extremely addictive and life-altering. That I don't have personal experience with anything that intense, so I can't speak from first-hand knowledge. Still, common understanding tells us that this kind of behavior rarely stays occasional. Once someone goes down that path, it usually takes control far quicker than they expect, which makes her statement difficult to believe. What makes this situation even more troubling is the impact on her children. If her claim isn't truthful, That raises the possibility that her kids were exposed to unsafe situations. Children deserve stability, safety, and proper care, and any risk to that is deeply concerning. Their well-being should always come first, no matter the circumstances. Now, I'm not saying judgment should come without facts. Everyone deserves fairness, and the legal system is built on the idea of innocence until proven otherwise. Still, it's hard to ignore the feeling that this could be an attempt to gain sympathy rather than take responsibility. Maybe I'm being too critical, and maybe there's more to the story than what we've heard so far. But in cases like this, explanations like these often don't hold up under closer scrutiny. Let me know what you think about it, and let's jump back in to see how the courtroom handles this moment.
All right, so how many children do you have?
I have three,
What are their ages?
11, 8, and 5.
And where are they now?
2 of them are with their dad and 1 is with my grandma.
All right. With your grandmother, so their great-grandmother?
Yes, ma'am.
All right. So, do you help take care of your children?
Yes.
How
I-
often?
I see them every other weekend, and I don't pay child support, but I pay them. My exes and I have my daughter. My daughter is with me.
No, you just said your daughter is with the
Yeah, but
great-grandmother.
I live with my grandmother. This was it.
All right.
So I help take care of her. She
Right.
helps me take care of her.
Okay. So one, I don't think it's appropriate for you to be cleaning houses
Okay.
because of the nature of this offense. And two, I don't think it's appropriate for you right now to be taking care of your children.
That's why I'm asking for help, Your Honor.
I'm sorry, what?
That's why I was asking for help, Your Honor. That's why.
All right, your help is not going to be outpatient treatment if I grant this application for deferred adjudication. So you're going into custody today.
Okay.
All right. So it's just a matter of what I'm going to do with you. I will tell you the court's issue, and if you want to address this, I know the state is proceeding on count 2 of possession, but she had a lot of drugs with her.
No,
So I don't understand if you're working homes, then why do you have a scale with you? Because that's, according to this, you had drugs, you had a scale in your purse, and there were baggies totaling 32.0 grams.
well, Your Honor, I was a heavy user back then, and it was.
Oh, I tell you what, I don't think, and if I'm wrong, correct me, I don't think you were using 32 grams of meth.
It was only 28.
No, you have meth here for 4.964 grams, and you also have meth for 27.459 grams. And what you pled to in count 2 was a possession 4 to 200 grams. So this is not a possession 1 to 4. So we're talking about 27 grams. And according to the stipulations, that what was found in your bag, it says, I searched her bag and inside a Paris Hilton makeup box were baggies, a scale, and crystal-like substance inside a cut vacuum sealed bag. That's from your Paris Hilton makeup bag.
Let's break this part down, because the details matter. Investigators reportedly found packaging materials, a scale, and illegal substances, which paints a very clear picture. That kind of setup doesn't usually line up with someone claiming they only get involved during moments of stress. It suggests planning, preparation, and repeated activity rather than a one-time mistake. Some people try to explain it away with comparisons that just don't hold up. Treating illegal behavior like it's some form of careful preparation only makes the explanation sound more disconnected from reality. Instead of clearing things up, it raises even more questions about intent and responsibility. From a legal standpoint, judges have heard every excuse in the book. Claiming casual or limited involvement rarely holds weight when physical evidence tells a different story. In fact, straightforward honesty often carries more credibility than stories that stretch logic. Courts tend to respond better to accountability than to explanations that feel rehearsed, but it's also worth noting that statements made under oath are taken very seriously. If the court believes someone is being untruthful, that can create additional legal trouble. While proving dishonesty can be difficult, inconsistencies don't go unnoticed, especially in a formal courtroom setting. At this point, the situation seems to call for transparency rather than denial. Owning the truth may be uncomfortable, but it's often the only path forward. Let's continue and see how the judge responds as this case moves ahead.
So what I had, the meth was it was double bagged in a sandwich bag. So yes, ma'am, I know it was 20, but it's because that was my personal. I didn't have any other. And last time I went, they tried to only give me which was 14 grams. So I had to.
No, what I'm telling you is, they said the baggie found in Robert's pocket tested positive for meth and had a field weight of
That was
6.12
Robert,
grams.
that wasn't mine.
No, I'm not saying that was yours. So the 6.12 grams that were found in his pocket, they're saying that was his. It was in his pocket. But the baggie, which was found in Missy's purse, tested positive for meth and had a field weight of 32.09 grams. Now, mind you, what they do in the field, I already know that testing drugs in the field are not legal for court. So I'm not considering the weight and what they said in the field. I'm considering what has been given to me for laboratory reports. So this was the professionals testing it, not a presumptive. And it says 27.459 grams was the net weight of the meth that you had in your Paris Hilton bag.
Yes, Your Honor. And I will say that I used to use a whole ounce within 2 to 3 days. So I was a heavy user, and like I said, they tried to give me half of that the last time, and right now it's going for $250. So if I'm paying $250, I wanted the whole thing. I wanted to make sure. I'm just being honest, and I'm sorry. Excuse me for being.
No, I
transparent.
want you to be honest, and I want you to be transparent.
I'm sorry for being transparent, but it's something that I feel like I worked for my money, and I didn't want just to get gypped again. I can promise you I didn't sell anything. It was because I've been gypped many times. So I did get it. Now it was double bagged because I don't know, that's the way they gave it to me. I can't, and it is my mistake, and I'm taking full responsibility, but I wasn't selling drugs. I wouldn't, I guess I have a job, and back then I was, a heavy user where I would just do it before work, after work, and I didn't have my children in my life. Now I do have my children back in my life, and I'm trying to be a good mom. So I thank you for, giving me an inpatient program.
Well, no, I'm not saying I'm going to give you
Oh, no, I'm
inpatient.
sorry.
What I'm saying is that you're not walking out of this courtroom today. Either you're going to be going to prison, or either you're going to be going to inpatient treatment. So it's very important that you be 100% honest with me, because I'm telling you, the state proceeded on a possession, but the amount of drugs you had and the way they were packaged, that's concerning for the court. So you're saying that you just bought a bunch of meth and you were saving it up for use?
So I would use within 2 to 3 days, that was all my personal. Like I said, they tried to sell me half of that one time, and I went back to the same person, but I said, I'm gonna weigh it myself to make sure I'm getting the right amount, because it's just, I'm an addict. I'm sorry, I am. And we're not.
So you travel with your own scale?
Well, at the time I did, because like I said, I've been gypped, and it's, when you're an addict, that's all you think of, just how to get, make sure you're getting what you need.
Let me ask you honestly, does this explanation sound believable to you at all? Even if someone was struggling with substance use, carrying packaging materials and a scale goes far beyond personal behavior. That's not accidental, and it's not something people casually keep on them without understanding the risks involved. From a practical standpoint, simply being found with illegal substances already brings serious legal trouble. But once tools commonly used for measuring and packaging are added to the situation, it changes how the case is viewed entirely. Those items don't just exist on their own. They strongly suggest preparation and intent. Legally speaking, this is where consequences escalate fast. Possession is one charge, but evidence that points toward distribution can open the door to far more severe accusations. At that point, the facts are speaking louder than any explanation offered in court, even without a single word being said. So the question becomes deeper than just belief. Is this a case of poor judgment, a calculated attempt to reduce responsibility, or a mix of both? The court has to decide based on evidence, not explanations alone. Share your thoughts below, because sentencing is coming up next, and this case is about to reach a critical moment. School.
And honestly, I can see where I made my mistake, but I won't, I'm being honest with you. it was my skeleton register, so my personal, that's it. And I don't know if Robert would tell you that was my personal as well. Like, I mean, I don't want to call him or anything you can if you want to, but he would tell you that's why I used to pick up.
Oh, no,
every
I'm not going to be
Thursday.
calling Robert because Robert probably has a case of his own.
Right. But I'm saying Robert can tell you too, within 3 days, maybe 2 to 3 days, really, it would have been gone and I would have been back doing it again. Now I don't. It was kind of like a stress thing. And
Where did you get your drugs to use today before you came to court?
um just an old friend. I hadn't talked to him since, and it was on Saturday when I knew it was, coming and I guess I felt, under pressure.
Can I say something? I think the fact that she would actually go out and do the same drugs that she's about to get sentenced for in a couple of days, I think really speaks to the fact that she has a serious addiction problem that I think only rehab can treat. And if you decide that's ISF or SATF or SAFE, we understand that, but I think she really needs treatment.
Okay. All right, this is what the court is there anything else for me to say? All right, this is what the court is going to do. I see that she hasn't been to prison before. I'm going to find her guilty, sentence her to 6 years in the prison, the therapeutic community. There's to be no contact with Robert Marble, give her credit for any time served, and I'll retain jurisdiction.
As the hearing continues, the defendant begins explaining herself directly to the court. She admits that she understands where things went wrong but insists that the items found were for personal use only. According to her, nothing was meant for anyone else, and she tries to emphasize that point repeatedly. She even suggests that someone close to her could confirm her story, though the court quickly shuts that idea down. The judge makes it clear that bringing other people into the case would only complicate matters, especially if they may have legal trouble of their own. The defendant continues speaking, explaining that her behavior follows a cycle. She admits that within a short time, she would likely fall back into the same pattern again, especially during stressful moments. That admission alone changes the tone of the room. When asked where she obtained the substances shortly before coming to court, her answer raises even more concern. She admits it came from someone she had not spoken to in a long time, and that she sought it out just days before sentencing. That detail strongly suggests a deeper problem rather than a one-time lapse in judgment at this point. It becomes clear that the issue is not just about the crime itself, but about an ongoing struggle. Even the defense acknowledges that this behavior points toward a serious dependency issue, one that punishment alone may not solve. Treatment and structured programs are presented as necessary steps if any real change is going to happen. The judge takes all of this into consideration before delivering the ruling. She notes that the defendant has no prior prison history, which plays a role in the final decision. Still, the court finds her guilty and issues a 6-year sentence, placing her in a program focused on rehabilitation and personal improvement. Restrictions are also set, including no contact with certain individuals and credit for time already served. Now comes the moment that sparks mixed reactions. 6 years is a serious sentence, especially considering the underlying struggles involved. On one hand, accountability is necessary. On the other, it's impossible not to think about the impact on her children, who will now grow up without their mother present. That reality weighs heavily on the situation. However, the judge also explains something critical: retain jurisdiction. This means the sentence is not necessarily set in stone. If the defendant follows the rules, avoids disciplinary issues, and actively participates in available programs, her attorney can request early probation after 6 months. This creates a narrow but real opportunity for change. The judge carefully explains what is expected. Participation in rehabilitation, parenting classes, and self-improvement programs is not optional. It's essential. Even signing up matters. Effort matters. The court wants to see commitment, not excuses. The message is firm but fair. The future depends entirely on the choices she makes from this point forward. There's also a strong warning. Showing up to court while still engaging in harmful behavior cannot happen again. The judge acknowledges the honesty shown but makes it clear that honesty must now be followed by action. The well-being of her children depends on it. As the hearing concludes, the tone shifts slightly. This ruling feels less like pure punishment and more like structured accountability. While the defendant did mislead the court earlier, she's still being given a chance to earn a second shot through good behavior and real effort that in the end, this decision may actually be the turning point she needs. Sometimes, fame consequences combined with support are what finally push someone to change. For her children especially, this could be the moment that alters the course of their future. Now I want to hear from you. Was this sentence fair, too harsh, or not strong enough? Share your thoughts below. If you enjoy thoughtful courtroom breakdowns like this, don't forget to like, subscribe, and suggest other hearings you'd like covered next. Thanks for watching, and take care.
And you can explain to her what that means. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, sir.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand?
Yes, sir.
All right, we can go off the record. I'll tell them. So here's the thing. When I say that I'm going to retain jurisdiction, what that means is they're going to take you to prison. If you're following the rules at the prison, if you're working on yourself, because they have programs at the prison, your attorney can file a motion. It's called shock probation. Back when I was growing up, they would have scared straight programs. So shock probation is sort of a scared straight program. So hopefully when you go to prison, you will clear your mind.
Yes.
The drug use or the addiction that you have, the craving that you have will be lifted. And if you are doing what you're supposed to do at the prison, if there are no bad reports at the prison, when your attorney comes back for a request for shock probation, I will strongly consider it. So while you're at the prison, you have 180 days. That's when he needs to bring it back before me before that time period. So you're going to do 6 months. And if you are doing well, if there are no write-ups against you, then the court will strongly consider giving you probation. You understand?
Yes, ma'am.
So, well, I mean, these are going to be choices that you make. It's going to be completely up to you whether or not I strongly consider giving you probation. Your attorney will explain it to you further, but any programs that they have at the prison, like the therapeutic community, to address your issue, you need to take it. I know they have parenting classes at the jail. I don't know how long the transfer will be, but you need to take advantage of that. When you see people come before me and they've gone to anger management class, they've done parenting classes, they've availed themselves of everything at the jail and everything at the prison, that is what you need to do. You need to immediately sign up for it. If for some reason there's overcrowding and they don't give it to you, it would be better for you to have signed up for it than to just throw up your hands and say, I'm not trying. Do you understand?
Yes.
And next time, if you have a case before any judge, don't use before coming to court. You understand? But I do appreciate your honesty, but you're going to have to get your life in order. Otherwise, children is going to be without their mom. You understand? All right. Good luck to you. You're welcome.
Thank you.